الحمد لله رب العالمين والصلاة والسلام على أشرف الأنبياء والمرسلين على نبينا محمد وعلى آله وصحبه أجمعين. اللهم لا علم لنا إلا ما علمتنا إنك أنت العليم الحكيم. اللهم علمنا ما ينفعنا وانفعنا بما علمتنا إنك أنت الجواد الكريم. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to another in this series on Al-Qawaid al-Fiqhiyya, Islamic Legal Maxims. And we're highlighting the relationship of these maxims with Islamic finance. We're talking about their relation in fiqh, or their applications in fiqh in general, but the particular focus on contemporary financial transactions. Nearing the end of this series, one of the remaining maxims is at-tabi'u tabi'un. Again, this is one of those examples of just this incredible compression of wording in a maxim. It only contains two words, and it's basically the same word, once being used as a subject and once as a predicate. And so what it means, if you strip it down to the literal translation, the auxiliary is auxiliary. Well, what does that mean? That which is auxiliary to something in fact is also auxiliary to it in its ruling. So in other words, something that's associated with or follows another thing in reality or in its ruling, or by law, de jure, then it takes the same ruling as its principle. So that one word, tabi', it's the active participle of the verb taba'a, which means to follow. So if you used it for a person, it would mean follower. So this is the same root word as we see in that term for the generation after the Sahaba, at-tabi'in. They're the ones who followed after the Sahaba. But when you use it as an adjective for a thing or a concept, and it means subsidiary, auxiliary, subordinate, and that's what we're talking about here. Could also mean secondary. Now, jurists divide tabi', or the auxiliary, into some categories. There's something that is auxiliary to another and dependent upon it because it's part of it. So the organs of an animal, the wool on the back of a sheep, and the leaves and the branches of a tree. And the second category is something that's auxiliary to another, but it can be separated from it. So an example for that would be the fetus in the womb or the fruit on a tree. And these two categories, we talked about them earlier in another maxim when we were talking about al-kharaju bid-daman, that liability becomes a justification for profit. And another way that something can be auxiliary to another is when it's necessary for it. So a key for a lock. A key by itself is useless. The lock by itself is useless. But the lock is what's primarily intended, and so the key is auxiliary to it. And then a fourth type of relationship here is where something is contingent upon another. So if you buy something and the delivery of the asset then becomes auxiliary to the purchase of it. It wouldn't do you a whole lot of good if you bought the thing and it's sitting somewhere other than where you need it. So delivery becomes an auxiliary to the purchase. So how do you know if something is auxiliary to another thing? Sometimes we know because the Sharia stipulates it. Sometimes we know it because it's built into the language, and sometimes we know it by custom, and sometimes we know it by a contractual stipulation. So these are kind of issues that have cropped up in our discussion of earlier topics related to this general field of qawaid fiqhiyya. And so the meaning of the maxim is that something which is auxiliary to something else, either de facto, which in Arabic is called haqiqi, or de jure, hukmi, will follow its principle and its ruling. And there's this famous book of qawaid fiqhiyya that was developed near the end of the Ottoman Empire by a committee of Ottoman jurists. It's called Majallat al-Ahkam al-Adliya, which gathered quite a few of the qawaid fiqhiyya, particularly in the Hanafi madhab. And it's still a source of law in many countries that used to be under the Ottoman rule before World War I. And so one of their articles, one of the maxims that's related to this principle, says, التابع لا يفرد بالحكم. Judgment cannot be given separately for that which is auxiliary to another. So, for instance, whatever is attached to real estate would take the ruling of its principle. And the organs of an animal would take the rulings of the animal itself, unless there was some kind of stipulation otherwise in a contract. For this principle to take effect, then jurists have stipulated two things. One is that the relationship, the auxiliary relationship, should be one of those four things that we just talked about, where it's a core part of the principle, or it's part of it but can be separated, or that it is necessary for the principle, or that it's contingent upon it. So that's one of the conditions. The other condition is that the idea that this is auxiliary to that should not conflict with some Sharia text where it says that, no, this is not auxiliary to that. If we look at the authority for this maxim, most of it basically, the textual evidence for it comes from the Sunnah. And it's also a matter of ijma' in general. Scholars agree upon the basic principle, although they may differ about some details related to how it applies to this or that case. And it also has a rational basis, that if something is auxiliary to something, you would expect it rationally to have the same ruling. But when we look at the Sunnah, the Prophet ﷺ, he said, if someone sells a fertilized date palm to another, its fruit belongs to the seller, unless the buyer stipulates otherwise. So this is a manifestation of that principle. When the date palm tree was fertilized, it belonged to party A. So that's part of his property right. So although he's transferring the ownership of the asl, he has a remaining right in that fruit, which was existent by the time he sold it. So the buyer can only acquire that right by stipulation. Another example is something that we mentioned in a previous episode. The Prophet ﷺ, he prohibited people from stopping the milking of a sheep or any milk animal before it's sold. A day or two or three before you sell it, you stop milking it. And so then the milk would collect in the udders of the animal. The buyer sees that the udders are full, and he thinks that, okay, this will be a good purchase. He takes it home, he milks it once, and all is fine and well. And then the next day he wants to milk it, and there's almost nothing in the udder. So he's dissatisfied with the sale. So he has a choice to take it back to the seller and get his money back. But what about that milk that he drank in the meantime? Well, the milk was already in the udder when he bought it. So the milk follows its principle, and therefore he has to compensate the owner of the animal for that milk. Another example of a hadith that talks about this issue, Abu Sa'id al-Khudri, he relates that they asked the Prophet ﷺ, sometimes we slaughter an animal, and when we open it up, there's a fetus inside. What's the rule for that fetus? Because, you're supposed to cut the throat of the animal in order to make it halal. So the Prophet ﷺ, he said, you can eat if you want to, because the zakat, the cutting of the throat of the mother, which is zakah, the zakah of the mother is also zakah for its fetus. Okay, let's take a break and we'll be back.
Assalamu alaikum. I am Dr. Idris. You are watching Peace TV, the solution for humanity.
Assalamu alaikum wa rahmatullah. Welcome back. Okay, we're discussing the maxim at-tabi'u tabi'un, and we've talked about some of its meaning, and we talked about some of the Sharia evidence for it. Now let's look at some applications of it. When we come to the issue of zakah, one of the categories on which zakah is due is trade merchandise. So the merchant, he has stock, and it's always turning over. So we're looking at when does the period, the normal rule for zakat is that the wealth has to be in the possession of the owner for a hawl, a full lunar year, before zakat becomes due upon that wealth. So what about the profit earned on the merchandise? So you've had the merchandise, or enough. You start the hawl, you've got the nisab, and then you look a year later and you still have the nisab in the value of the merchandise. And so the profits that are on hand at the time that zakat becomes due, you've only had those profits for a little while, perhaps. But because the profit was derived from that merchandise and the zakat is due on the original merchandise, then zakat is also supposed to be paid on the profit that's been earned from it. This is a fairly common sense example. The next one, you wouldn't need to be a faqih to understand the ruling for that. If somebody sells real estate to another person, then everything that's auxiliary to that real estate is also transferred. So the person would have the right to buildings on that real estate and also easement rights. Like, for instance, access. The person can pass through somebody else's property to get to his land. Well, that right is also transferred with the ownership to the new owner. We were talking earlier about wool on the back of a sheep or milk in the udder of the sheep. It's not permitted to sell wool while it's on the back of a sheep, because at that point it's auxiliary to the sheep itself, and you're not selling the sheep, so you can't sell the wool. In order to sell the wool, you have to shear the sheep, take the wool off, and then it's permitted to sell it by itself, because it's no longer tabi'. And this is a reflection of that principle that we mentioned earlier, at-tabi'u la yufradu bil-hukm. The auxiliary cannot be given independent ruling from its principle. If we look at specifically issues related to Islamic finance, you have an example in corporate shares. It's prohibited to sell debt to a third party. There are complicated rules for it, but the basic rule is that if debts comprise a significant, let's say more than 50% of the value of a stock, then it's not permissible to trade that in the secondary market. Now, what exactly is the amount that will trigger this prohibition? These standard-setting bodies, composed of Sharia scholars, they make ijtihad, and they've set certain limits that if it's above that limit, it's haram to trade it, and if it's below the limit, then it's permissible to trade. And the principle that they're invoking in order to make that ruling is the idea that when the receivables, the debt portion, is less than the other portion, then it takes its ruling from the dominant component of the share. So it doesn't take an independent ruling. Now, that's perhaps, I mean, there are always people who are willing to dispute these kind of points. I mean, they're judgment calls, they're ijtihadi issues. So you could probably find scholars who would dispute that ruling, but if you say that it's haram to do that, if there's any percentage of debt component in a company's shares, then basically you make it impossible to trade shares. And the implications that that would have for an economy would be very negative. So sometimes you can have a purist position on an issue that leads to great difficulty and hardship in the society. That would be one of the examples of a kind of opinion, a hardline sort of opinion, that would severely reduce economic activity in a society, which would have negative impact on everybody living in it. Another application, it's permitted for a takaful operator. We mentioned in earlier episodes that takaful is an Islamic alternative to insurance. It's permitted for a takaful operator to underwrite the risk of a company whose core business is halal, but borrows from conventional banks. Again, the same issue could come up. Hardliners would say, no, if there's anything that's traces of or minority component of haram would still disqualify. However, the same response would be given to that objection. And yet another version, this issue just keeps coming up. If the core business of a company is Sharia compliant, but it has some Sharia non-compliant activities below the threshold stipulated by the standard-setting body of that jurisdiction, it is permissible to trade its shares because the impermissible activities follow the ruling of the core activities which are lawful. This principle, this maxim, even though it's not one of the 5 major maxims, it does have some subsidiaries. For instance, التابع يسقط بسقوط المتبوع. If the principle is dropped, the auxiliary is also dropped. There's another wording of it, which we'll come to in a minute. التابع لا يتقدم على المتبوع. The auxiliary does not take precedence over the principle. يغتفر في التوابع ما لا يغتفر في غيرها. Issues may be excused in auxiliaries that are not excused in other things. So if we look at one of those corollaries, إذا بطل الشيء بطل ما في ضمنه. It's another wording of the first corollary I mentioned. When a thing becomes null and void, what is included in it becomes null and void too. And if we look at an example of what that means, a sale contract carries with it, when it's concluded, it brings into effect legal effects. So the buyer, he now has the ownership rights to what's been sold, and the seller has ownership rights to the price, and various other legal effects would take place. If it turns out that there was something wrong with that sale and it's invalid, then it's kind of a no-brainer. The sale is invalid, so all of its effects are also invalid. That means that the seller should take back his good and the buyer should take back what he paid for it. So an example of that would be if a Muslim purchased alcohol from a non-Muslim, the whole thing becomes invalid. One of the examples of this, what I'm talking about here is from the book that our institute has spent the last 2 years preparing. It's about to be published. Islamic Legal Maxims and their application in Islamic finance. So we sent the book out to an outside reader who is a Sharia scholar, and he sits on a Sharia committee for an Islamic bank. So when he read this example that I'm about to mention to you, he said, "This example doesn't make any sense at all. Who would do that?" But lillahi fi khalqihi shu'un. We disregarded his objection because this is a real thing. You know, it's happened and it's happening. In the West, they have this custom that's starting to make its appearance, which is that after 10 years or whatever, married couples renew their vows. So they have a new ceremony, and they gather their friends, they go through the whole marriage ceremony again. And the Prophet ﷺ, he said that you will follow the ways of the people before you, inch by inch, step by step, until if one of them entered into a lizard hole, then someone from this ummah would enter into a lizard hole as well. So if a Muslim couple were to follow that custom and to renew their marriage vows, and the husband promises his wife a new mahr, then, you know, this whole new marriage is la mahalla laha min al-i'rab. It has no place, you know, it has no legal effect. So therefore the mahr, also the wife has no right to it because it's an auxiliary of the marriage contract, which is itself invalid. Another example of this would be what's called istihqaq. Somebody sells something to another, and then it turns out that he's not the owner. So in that case, of course, the sale is invalid, and so all of its legal effects would be invalid. We've come to the end of our time. Assalamu alaikum wa rahmatullahi wa barakatuh. Wallahu a'lam.
إلهي أنت ربي ذو الجلال عالم